Please be seated. Proceedings are resumed. I'll recognize the Honorable Deputy Governor.
Madam Speaker, thank you. I think we have agreed that we all care about this young man. We would all love to see him take up the job of his dreams. So on that basis, we are not going to read out verbatim the letter that was given to him, which the member from East End had with him when he asked me the question why he wasn't given the job. It's all very clear right here. So we have agreed, Madam Speaker, to just give a summary. So all I will say, Madam Speaker, is that the director had specific reasons why he didn't do it. It is clearly documented here. I am reading this. I am satisfied that this would be a decision that would be in keeping with the civil service high standards of performance. And Madam Speaker, I would like to just make note that this young man has been invited in writing in this letter by the director to take part in the next recruitment exercise, and I would implore him to do so. Madam Speaker, I want to make it very clear, and I accept, while we are at 74% Caymanian in the civil service, and I crave your indulgence, ma'am, the prison service, our teaching, our police service, those are where there are high concentration of non-Caymanians, and that is for a reason, Madam Speaker. Must we do better? Absolutely. Are we committed to doing it? Absolutely. We have run 2 recruitment classes now at the prison under the new director, and we have gotten Caymanians employed. We will continue to do that, Madam Speaker. I want to give an undertaking here. We will continue to do our best to get our Caymanians into these jobs in the civil service. That is my commitment. That is my job. And I take that responsibility very seriously. I would implore this young man to get in contact with me. I'll be happy to sit with him, go through this inner concerns he has to ensure that they are properly addressed. Madam Speaker, I'll say it again. I started here in the civil service when I was 16. I want as many Caymanians as possible to follow in my footsteps, and I am doing my endeavor best to make sure that happens. I would ask all members of this House to, when they get concerns about civil service matters, rather than bringing it to the floor of this House, they engage with us, tell us what's happening, and give us an opportunity to address them. Thank you very much, Madam Speaker.
Before calling on the clerk, I just wanted to recognize the Rotary Club for the Adventures in Citizenship Essay Competition, that they're finalists along with Mrs. Deanna Lookloyd. We're here in the gallery early this morning. They've had to leave now, but we'd like to, through the Rotarians here and others, let them know that we appreciate them taking the time to see how the government works. Madam Clerk.
The elected member for Northside to ask Honourable Minister of District Administration, Tourism and Transport, question number 48.
I recognize the Honourable Member from the District of Northside.
Thank you, Madam Speaker. Madam Speaker, I beg to ask the Honourable Minister responsible for Administration, Tourism and Transport. Can the Honourable Minister give an update as to when the water sports zones prescribed in the Water Authority law and regulations will be properly demarcated?
Port Authority. Honourable Deputy Premier.
Thank you, Madam Speaker, and thank the member for the question. The answer, the Port Authority of the Cayman Islands and the Department of Environment has formed a committee to review the current water sports areas. that are prescribed in the port regulations. The committee has prepared recommended changes to the current water sports areas designated in the port regulations. Recommended changes have been reviewed by the ministry and are to be sent to caucus and cabinet for consideration. Once the changes are approved by cabinet, Port Authority will embark on demarcating these areas.
If there are no supplementaries, member from Northside.
Through you, Madam Speaker, I wonder if the member would agree to let me know what the proposed changes are, because two of these areas are in my constituency, and I was involved in the original creation of these in 1985, 86. Hopefully before it goes to caucus and cabinet, because I would like to take it to, this involves my community. The way we do things in Northside is we take these kind of things to our community, to the district council, particular now that people have gotten used to using these areas over the last several decades.
Honorable Deputy Premier.
Thank you, Madam Speaker. Madam Speaker, to the member, I'd be happy to provide that, and I think it might be prudent if I provide it for all members and let them give input. And I can do that in a very short period of time. So thank you very much.
Member from Easton, were you trying to catch my eye? Honorable member from the District of Easton.
Madam Speaker, now that we're on the subject of demarcation, I was just wondering if the minister could give us an undertaking about our channels, see if anyone, you can look into the proper mark and enlighten of those channels.
Honorable Deputy Premier.
Yes, Madam Speaker, I can give that undertaking.
Madam Clerk.
The elected member for Northside to ask the Honourable Minister of District Administration, Tourism and Transport, question number 49.
Recognize the honorable member from the District of Northside.
Thank you, Madam Speaker. Madam Speaker, I beg to ask the Honorable Minister for District Administration, Tourism and Transport the following question in my name. Can the Honorable Minister give the average load factor of passengers on the Miami to Cayman Brac and the Cayman Brac to Holguin, Cuba Saturday flights by Cayman Airways?
Recognize the Honorable Deputy Premier.
Thank you, Madam Speaker. Yes, Madam Speaker, the answer. During the first 2 months of the Hugain route's launch, the average load factor between Miami and Cayman Brac was 48%. The average load factor between Cayman Brac and Hugain was 37%.
If there are no supplementaries, we'll move on to the next question.
The elected member for Northside to ask the Honourable Minister of Planning, Lands, Agriculture, Housing and Infrastructure, question number 50.
I recognize the honorable member from the District of Northside.
Thank you, Madam Speaker. Madam Speaker, I beg to ask the Honorable Minister of Planning, Lands, Agriculture, Housing and Infrastructure the following question. Can the Honorable member say what rights do the general boating public have in using canals and other waterways that connect to the North South?
Recognize the honorable minister responsible for planning.
Madam Speaker, I'm going to read the answer, but I want to make it very clear that what this answer is what's supposed to happen. Madam Speaker, in order for the general public to traverse these canals or waterways, which are parcels and may be owned privately or by the Crown, access will need to be granted by the owners. This access will be subject to prevailing interests which are registered against the particular parcel in question. The interests which could be recorded are easements, restrictive agreements, profits, licenses, that is, if there's a caution lodged at the Lands and Survey against the parcel. And just to add one more thing, and to use an example which the member will probably be familiar with. The canal which runs parallel to the road going from Rum Point to the Caibo, that canal. And of course, these are discoveries only when something happens and somebody needs to do something. When that subdivision was originally done, that canal was a parcel of the larger parcel going, I want to say, to the east. And nothing was ever done about it over all the years, although the landowners used that canal. And I remember one specific landowner, after the parcel changed hands, I remember one specific landowner speaking to me directly. Unfortunately, he's deceased now, but I remember him speaking to me directly and asking why did he have to gain permission from the landowner to be able to build a dock at the rear of his lot, which butts and binds the canal. And that was when persons like myself discovered the situation with that canal. But the way, and I think in more recent times, people are more careful of how the rights are registered and such the like. But my answer is simply to say that many people just simply use it at will, but it is not that they're doing so legally. So if they were to follow the law and they wanted to go up in and out of there with their jet ski or whatever, the fact is they should gain permission from the landowner.
Member from Northside.
Through you, Madam Speaker. Madam Speaker, can the member say if the government is giving any consideration to creating legislation or whatever is necessary to treat these canals like public roads? Because the risk is that any particular owner in this situation can tell every other owner who's upland of him that he can't pass the canal in front of him. And all of those people, but he can refuse to give them the easement. Any particular owner who has bought a lot on that canal under the clear understanding that buying it was a canal lot and he had the right to use it. Let's go back to your exact chance. If the owners of that parcel now, if I buy a lot at the entrance of that canal from K's, which is the development that now owns the canal, I can refuse to tell you, you can't pass to get to build a dock. Because I own the parcel on which the canal is on. And if I don't give him an easement or give him permission to use it, he can't use it. That's what people are being told. And it has a potential, not just on that one, island-wide. And I would encourage the government to look at finding a way to treat them as roads, because if you want to build a dock, you got to apply for coastal works to do what we call the Queen's Bottom, because it's an extension of the north side. And that's a private lot.
Recognized Honorable Minister responsible for planning.
Madam Chairman, Madam Speaker, forgive me. I believe I understand what the member is saying now. And this same incident I spoke to you about caused me to speak to them. And I still await a report on asking the same question you're asking, what's the best way to handle it? But what I don't think that you and I are on all fours with, member from Northside, is if I own a lot on that canal and I have an easement from the owner of the canal for my lot, that doesn't give me the right to prevent anybody else from access. If they're being told that, that's incorrect. It is only the owner can say that someone can't traverse. The owner of the canal.
Members, let's keep the comments through the chair, please.
You mean from the other side? That, now I'm with you. I was thinking from, okay, now I fully understand exactly what you're saying, and I agree with what you're saying if that is how it is. Are you sure that the lot itself, no, I'm just asking, are you sure that the lot itself includes the waterway? Because while the main parcel, when it was sold, included the canal, and I can check to make sure, the subdivision itself, as I understand it, does not include the water going over to the next side. If that is the case, then we will have to do something about that specific instance fast. But back to the general discussion of what you're saying, you are correct about the possibility. I don't think we have many of those specific situations anymore. That's a long-standing one, but as a matter of principle, we have to ensure to make the situation such that that can't occur. And I take your point, and I certainly will have more discussions with the Lands and Survey Department to ensure that that's done. You see, the government can do compulsory acquisition. Of course, that process means you have to get a valuation. I'm just telling you. And you have to lodge money. Once you get a valuation that you consider to be fair, you have to lodge money in the courts, go through the process, make sure that all parties are satisfied. So it is not quite as simple as gazetting it. It's comparable, but it's not quite as simple as that. And after you gazette it, then you deal with the rest afterwards. But from the perspective of landowners on canals having difficulty, then certainly we need to solve that problem and find a way. When the question was asked and I looked at it, and in talking with the department, it's a bit difficult for people who just are moving back and forth. But for landowners, then that's a matter that we need to make sure that the encumbrance is not there for them, that they can't use it when they are backing up on it.
Honorable member from Northside, followed by the member from East End.
Through you, Madam Speaker, can the minister say if he is available, if he is aware, that the Port Authority has constructed a wall on its property in Safe Haven to prevent Caymanians from tying up on to Port Authority land because the canal is owned by Dragon Bay, and they have said they can't tie up there because they own the canal. Even though there is an agreement to register an easement, the easement, to my knowledge, or at least up until 2 weeks ago, has not been registered. And that the Ritz-Carlton are telling these people they can't anchor their boats in the larger area of the canal because they own the canal, and they have been told that they are going to be evicted. So it is a matter that I believe is going to get increasingly contentious. And we need to, I'm just asking the government to look into a way, it might not be the correct way to gazette them as public use, but maybe register an easement over it, which might not involve a lot of money, but a public easement. And make sure that in the future, when canals are done, they are not individually parcelized where owners can own them.
Honorable Minister responsible for planning.
Thank you. Madam Speaker, I am acutely aware of that specific situation. And we have been in discussions and have been given assurances that the easements are in the process of being granted. Has to be done through the Port Authority and the legal counsel for both sides. The legal counsel for both sides are in the process of sorting the matter out. That situation is this, just so that the member will know. The Ritz-Carlton doesn't have an easement from their waterway, a registered easement, into the canal leading out to the North Sound. So the Ritz-Carlton, their mind says, listen, we won't have a problem with you all using our waterway. You just make sure that we get an easement out to the thing, so out to the North Sound. So just making you know that I know. And I understand. I understand now. But we have said to them, listen, let's face reality. Whatever wasn't done right, either out of ignorance or inadvertently or for whatever reason, practical reality of the situation is you can't deny these people this right. Do we get into a fight? Which I don't like. But if you force my hand, we will. Or do we act sensibly and move the process through? So just so that the member will know, I'm following up the situation, and I will, in fact, you have prodded me now to ask the ministry to check with the legal counsel to see whether or how far it's at. But I think it's imminent to sort that matter out.
If there are no further member from Easton, beg your pardon.
Sorry. Thank you, Madam Speaker. Madam Speaker, the minister said that those waterways are private. It's a parcel, I believe. Is it not so that you require a coastal works license to build a dock on those?
Recognize the Honorable Minister.
Madam Speaker, I personally would prefer to make sure of what I'm saying, but here's what I believe, and I'll check to make sure that what I believe is right is exactly the case. If it's a privately owned canal, meaning it's not Crown, although the answer speaks to private including Crown, but I mean if a private entity owns the canal, within the precincts of that canal, you do not need a coastal works license. If it is the Crown, then you have to apply to the Crown to be allowed to build a dock. If it's open waterway, then you have to apply for a coastal works license. But a registered parcel in a private, either individual name or the name of a company or any other entity, that is really not considered Queen's Bottom.
Honorable member from the District of Easton.
Thank you, Madam
Just
Speaker.
quickly, Madam Speaker. It clearly being understood that is man-made, not natural.
Member from Easton.
Thank you, Madam Speaker. And I wonder if the minister can tell us, I know in many years ago, it used to have a lot number, like Snow Harbor, but they don't anymore. There is a lot number on canals now, continue to be given? Okay. So is there a requirement for them to get coastal works license to tie into the North Sound?
Honorable Minister for Planning.
Thank you. You would then be speaking of the very end where it connects. Then you would, at that point. Yes. Because you are going in to the Queen's bottom. I hear you, but I'm just telling you what obtains. Madam Speaker, just for practical purposes, the biggest reason for all of that is to guard against people doing it in the wrong way, not having the proper silt screening, all of that when you go out into the open water. If you're doing an inland canal, let's say there's a subdivision, it has a series of canals, but only one entrance out into the North Sound. You're not applying for a coastal works license for all of that stuff in there. You're applying for a coastal works license for when you open that waterway to join into the North Sound. That's the reason. And they do still get parcel numbers. They do.
If there are no further supplementaries, we'll move on to the next item of business.
Statements by honorable members and ministers of the cabinet.
None.
Personal explanations.
None.
Obituary and other ceremonial speeches.
None.
Raising of matters of privileges.
None.
Government business. Bills. Second readings. The Health Services Authority Amendment Bill 2016. Continuation of debate.
I'll recognize the Honorable Premier for the continuation of the debate on the Health Services Authority Amendment Bill 2016. The clerk could give an indication as to how much time remaining for the Honorable Premier.
Thank you, Madam Speaker. Madam Speaker, when the House adjourned on Wednesday evening, I had just concluded reading an excerpt or excerpts from the Hansard, official Hansard report of this Honorable House for Monday the 13th of December 2004. And in particular, I had just concluded reading what is recorded as my contribution to the debate at the time with respect to how this Section 12.3 provision came about. More precisely, the amendment to what was then Section 12.3, which has now become the subject of much controversy, a court case, judgment, and ultimately this proposal by the government to amend Section 12.3 to remove the immunity which is presently conferred on employees of the Health Services Authority, which prevents them from ever being able to be sued regardless of their actions regardless of the negligence or regardless of any negligence which of which they may be or for which they may be liable. Madam Speaker, I pointed out that during that important debate that I had specifically targeted the issue of this immunity because section 12.3 and the new section which was to be inserted dealt with two separate and distinct things. One was conferring immunity on employees and directors, and the other was government providing directors with an indemnity against actions brought against them as a result of the discharge of their functions or duties, as long as those weren't carried out in bad faith. And it is the immunity bit that we are seeking to resolve. Madam Speaker, as I said, and my contention was and is that despite utterances by the leader of the opposition and the former Minister of Health at the time recently, that it was not government's intention to actually exempt employees from liability in these sorts of instances. All of the correspondence, all of the debate actually points the other way. And I would not have gone down this road had it not been stated so categorically to the media that that was not government's intention. It plainly was. There was and is internal correspondence which points to the issue, and the debate in the House at the time plainly demonstrates that despite the fact the government was advised, well, that's too strong a word, it was brought to the government's attention by the opposition in the persons of the then leader of the opposition, now Minister Kurt Tibbetts, and myself, the effect that this section was going to have. The government still proceeded to amend the bill. And Madam Speaker, I think in fairness, because I believed in being fair, I should complete my reading of the Hansards with the contribution of the then minister in winding up on the bill, him having by that point heard what the then leader of the opposition and myself had to say about the matter. And that, Madam Speaker, is at page 515 of the official Hansard reports for Monday, 13th December 2004. The Honorable Gilbert A. McLean said, "Thank you, Mr. Speaker. This bill is before this Honorable House because it was considered by the Board of Directors long before now, and the favorite time or incident of the second elected member for Georgetown, who, Madam Speaker, was myself at the time, that the Board felt there should be a change to the wording in Section 12. Also, the Board has been discussing from last year the question of indemnity. Various correspondences have gone between the Board of the Health Services Authority and the Legal Department with proposed wordings. The present wording here is what I have been given as legal advice from the government's chief legal advisor." I don't remember who that was at the time, but I'm sure we can find out. "I have let the Board understand the Constitution says that government's chief legal advisor is the Attorney General, and when I am given a wording that he or she thinks is acceptable to meet the wishes of the people who serve on the Board of the Health Services Authority, I am obliged to accept that. I can say to the member that there is certain disagreement still with the legal wording, but the wording that I have to use or to bring to this Honorable House is that which satisfies the legal department of government and the Attorney General. And so, Madam Speaker, what the Minister is saying is there are, or seems to be saying, there are certain reservations that some of us have about this, but the legal advice we have is this, which again underlines the point I've made, is that this is a decision that was taken by the government with full knowledge and appreciation, or must have been, of its impact. They've had the benefit of legal advice. There's even some disagreement about it, but nonetheless, the government proceeded on the basis, this is the advice of the principal legal advisor, and this is what we're going with. I brought it to answer the second elected member for Georgetown because I am always prepared to do what has to be done, what is right to be done, when it needs to be done. And in this case, the closest we got to acceptable language, and indeed the new proposed clause on indemnity, was now, and therefore I brought the bill to this Honorable House. I repeat that this has been a matter which has been ongoing from last year, long before his friend Elliot got into the picture, or that he took up, it seems, on paid representation on his behalf. So it has nothing to do with any such case, but I can understand that is something which the second elected member for Georgetown cannot free his mind from, and that he would now use that to discuss the two clauses which are proposed for inclusion in the Health Services Authority. If he was making advocacy for what might come of the case, he cited, I'm sure the judiciary will take note of what is said in here, including what he said, what he and I said, and make its own determination. The section that you drew members' attention says that where there is a matter which judicial decision is pending on, it should be avoided in debate. I will not take any more time to discuss the most favorite subject of the second elected member for Georgetown in my presentation. Mr. Speaker, yes, ma'am.
Sorry for the interruption. I'm informed that you have 1 hour and 35 minutes remaining.
I hope I don't need all of that, ma'am. Thank you. Mr. Speaker, as the Minister of Community Affairs stated, it is my understanding under advice that the words dishonesty, the acts dishonesty, in quotations, both fraud, in quotations, and willful neglect, in quotations, are covered under the term bad faith, in quotations. He may have noted that the words or purported discharge, in quotations, has been taken out of the proposed insertion, and I am made to understand that if anything that may have been given greater comfort to directors, if anything that may have given greater comfort to directors, but that has been taken out. Again, he has his legal view, and I'm sure the legal department has theirs. The indemnity was not included in the law at all. I can recall from the very first meeting of members of the board of directors asked why there was not an indemnity clause. These are business people, and they understand having a fiduciary duty, as the second elected member for Georgetown has said, and they inquired about it. It is only now that it has been done, and we have heard that the wheels of justice grind slowly, but surely, and I think that is true of government's action as well. So both of these amendments are before this Honorable House for no other reasons than they are seen to be sufficient, and they have gotten as close as possible to meet the desires of the board of directors and the legal department. I can give no better explanation than that. And then, Madam Speaker, the rest of the then minister's contribution goes on to talk about other aspects that were included in the amending bill regarding the Dr. Horder Memorial site, and so forth, not relevant to the issue. And so, Madam Speaker, the short point in all of this is that for reasons which I am still not, I'm still not entirely clear on all these years hence, there was, the indemnity bit is obvious and clear. There was put into the law a provision which relieved and still relieves employees of responsibility, legal responsibility, in the event of negligence. And that is the mischief this proposed amendment by the government is seeking to cure. Madam Speaker, because this has such a storied history, we are doing our very best to ensure that we don't repeat the errors of the past. And so the current Attorney General has sought the advice of senior counsel, and I have, as a result of his efforts, an opinion with respect to the proposed change to the legislation. And Madam Speaker, I think in the interest of full disclosure, it is important that I let members of this House and the broader public know what that opinion says. And so I'm proposing, Madam Speaker, with your leave, to read it. It is quite short, as these things go, but it's very instructive.
Please proceed.
Madam Speaker, it is an opinion obtained from Blackstone Chambers. The counsel involved is Mr. Mark Shaw, QC.
Do you have copies, or you wish to
Yes, ma'am.
have the sergeant make them?
I have some copies. I don't think we have enough for all members, but certainly for
Sergeant, if you could make some copies, please.
certainly for you, Madam Speaker, and I
Thank
think
you.
there's one spare one, which the sergeant may use to copy.
Please proceed, Honorable Premier.
The Attorney General seeks, I'm reading the opinion now. The Attorney General seeks my advice on a proposed amendment to Section 12 of the Health Services Authority Law, 2010 revision, due to be debated in the Legislative Assembly in early May 2016. Well, we've beat that date. If enacted, the amendment would remove the current bar on clinical negligence claims against the Health Services Authority, its employees, directors, and committee members. A claim for damages against any of those defendants cannot presently proceed unless the plaintiff identifies some act or omission done in bad faith. As it stands, Section 12 provides as follows. Neither the authority, nor any director or employee of the authority, nor any committee member shall be liable in damages for anything done or omitted in the discharge of their respective functions or duties unless it is shown that the act or omission was in bad faith. Clause 2 of the Health Services Authority Amendment Bill would repeal that provision and substitute a new Section 12 as follows. Neither the authority, nor any director, nor any committee member shall be liable in damages for anything done or omitted in the discharge of their respective functions or duties unless it is shown that the act or omission was negligent or in bad faith. Clause 3 of the bill would make a consequential and parallel amendment to Section 13 of the law to remove the indemnity conferred in respect of the negligent acts of directors and committee members by inserting the words negligence or before the words bad faith. The bill contemplates no other changes to the statutory language. In my view, the proposed amendments would strike a legitimate balance between the competing interests of, on the one hand, plaintiffs seeking damages for loss caused by negligence, and on the other hand, the authority and its personnel who deserve protection from arbitrary and/or frivolous claims. As currently framed, Section 12 is out of step with the treatment of clinical negligence claims in other advanced legal systems. An absolute ban on the adjudication of such claims works considerable injustice in individual instances, as recently illustrated by the case of Danette Thompson and the Cayman Islands Health Services Authority and other, cause number 190 of 2013, 19th of January 2016. Madam Speaker, the House will remember that that is the judgment from which I read on Monday evening. As the Grand Court there explained, in paragraphs 118 and 119 of its judgment, it felt, quote, uncomfortable with such immunity, unquote, and regarded its consequences as, quote, troubling, unquote. Although driven to uphold and enforce the ban by the, quote, unambiguous and clear words, unquote, of Section 12, the Grand Court suggested that a government, quote, may feel it appropriate to openly clarify to the voting and wider public who it is obligated to serve and protect, whether its declared policy is to retain legislation that denies remedies in tort for medical negligence, and to explain the justification for such a policy at this time. And I pause here, Madam Speaker, to interject that, as I said at the start, when I opened my speech with respect to this bill, this government feels that we should not seek to protect employees or directors from claims for negligence on their part. We are dealing, in this instance, literally with people's lives. And if a doctor or a nurse or someone else is negligent and is found so to be, the injured party deserves to be able to have the appropriate redress. I return to the opinion. The extremity of the ban is hardly moderated by the explicit exception for bad faith. It is notoriously difficult to demonstrate such malicious motivation. Any plaintiff bears the burden of proving that the defendant intended to cause harm, or arguably that the relevant act or omission was reckless and the defendant did not care whether harm resulted. Any healthcare worker found to have behaved in that manner would not only have contravened the fundamental tenets of their profession, but would also very probably be exposed to criminal liability. Such findings must surely, therefore, be extremely rare. By contrast, the proposed amended wording would bring sections 12 and 13 into line with the basic constitutional principle of access to justice, which anticipates redress for negligent acts or omissions. Indeed, accessible, effective, fair, and independent adjudication is one of the hallmarks of the rule of law and democratic governance. Remedies for negligence are recognized worldwide as a key part of that legal security to be provided by a state for its citizens. Although the proposed amendment does not seek explicitly to exclude frivolous, scurrilous, and or vexatious claims, defendants would surely benefit from that protection without it being spelled out. Courts have general and inherent powers to strike out a claim, both as soon as it is brought and as it evolves, if it appears to disclose no reasonable grounds or is abusive. Defendants are also entitled to apply for a claim's summary dismissal if it has no real prospect of succeeding and there is no other compelling reason for a trial. Both powers can be exercised on the application of a party or on the court's own initiative. Beyond that, defendants are safeguarded by the burden on any plaintiff to prove that all the exacting requirements of the tort of negligence are satisfied in the circumstances of their particular case. 1, a duty of care owed by the defendant to the plaintiff. 2, a breach of that duty by the defendant. And 3, reasonably foreseeable loss caused to the plaintiff by that breach. The proposed amendment would do nothing to lighten any plaintiff's burden in that regard. Finally, the court's wide-ranging power to make adverse cost orders, including on the more penal indemnity basis, deters overambitious or malevolent plaintiffs. And so, Madam Speaker, we have the comfort, if I may use that word, of this opinion to underpin the policy decision that this administration has taken. Madam Speaker, I should also, for the sake of completeness, I should also indicate that the judgment which is referred to in the opinion and from which I read on Monday is not presently the end of that particular litigation in the Donette Thompson against the Cayman Islands Health Services Authority and another matter, because there is still outstanding, and so I won't speak about it really, a separate and distinct challenge based on a claim that the legislation as it currently stands, Section 12.3 of the HSA law, is incompatible with certain provisions of the Bill of Rights. And so we will see where that claim gets to. But, Madam Speaker, certainly with respect to future claims, the amendment which is being proposed now will avoid the necessity for that sort of approach. And that leads me, Madam Speaker, to say that we have been approached, we being the government, have been approached by some, I'm trying to find the right, let me just say some, by some lawyers for potential plaintiffs who claim or who would like to claim negligence with respect to the actions or omissions of HSA personnel, and who have lobbied and are advocating that this change to the legislation ought to be retroactive or retrospective. I'm never quite sure of the distinction between the two, so I'll use both. And that, in other words, that it should go back to 2002 when the law was changed and allow in all potential claims which might be made, but which could not have been made because they were debarred by this section. Madam Speaker, the government has looked at this, and we have concluded that it is not a policy decision that we can possibly take. We have no way of knowing how many potential claims are out there. We have no way of quantifying what the possible result could be in terms of damages awarded. The insurance policies which have been obtained by the Health Services Authority over that period and the premiums paid would have been and were on the basis of this immunity provided for in the legislation. The result would be that the HSA would be exposed and without an insurer with respect to any such claims for that period. And so, for those reasons, as empathetic as the government is to plaintiffs who have been, potential plaintiffs who have been shut out by the legislation which has been in place since 2002 until now, some 14 almost 14 years. It is not a decision, a policy decision that we can take to make this legislation retroactive.
Honorable Premier, is this appropriate time for the luncheon break?
Madam Speaker, indeed it is. In fact, I was just about to say to you that I believe concludes my presentation with respect to moving the bill. I will look forward to what other members may have to say, and as always reserve the right to address those issues and some others if it becomes necessary as a result of what other members may say. I thank you, Madam Speaker.
The House will now take its luncheon break, and we will resume at 2:30 p.m.